Okay, moving on to our next witness. Thank you. Stick around. Don't go too far. Mr. Snead?
Yes. I'm Professor of Law at the University of Notre Dame. I'm here to provide testimony on a narrow question, namely whether SB1's prohibition on abortion at or after 20 weeks post-fertilization is lawful under the United States Constitution. There is absolutely nothing in the text, history, or tradition of the U.S. Constitution that precludes the state of Texas from extending the most basic protections of the law to 20-week-old or older unborn children who are capable of experiencing pain. For your purposes as legislators, this is sufficient constitutional warrant to enact the modest restriction on abortion that SB1 provides. Moreover, there are no precedents of the Supreme Court that speak precisely to the very unique features of the proposed 20-week abortion ban. This provides additional constitutional grounds to enact SB1. I will now reflect briefly on how relevant Supreme Court precedents bear on SB1. At the heart of the Court's jurisprudence has been a quest to strike a balance between the state's interest in the lives of unborn children at all stages of pregnancy and a woman's liberty interest in seeking an abortion. Justice Kennedy, whose vote is always decisive, has clearly signaled an openness to the possibility of new state interests that might affect the calculus of competing claims in this area of the law. Texas has recently identified a state interest never before considered, namely its duty to protect unborn children capable of experiencing the excruciating pain involved in an abortion. The capacity of unborn children to experience pain by 20 weeks gestation is a decidedly new and deeply salient moral fact that weighs heavily in favor of the unborn child in the balance crucial to the Court's jurisprudence. It provides a novel, constitutionally significant interest that the state may invoke to justify SB1. This new information about the nature of the unborn child forces us to confront the fact that she is one of us, not merely insofar as she is a living member of the human species, but also in that she experiences pain much as we do, perhaps even more acutely. This insight about who the unborn child is offers a new and overwhelming justification to limit abortions, certainly to the very modest extent that SB1 would. And I've submitted testimony that is a more extended analysis of the Supreme Court precedents, and I'm happy to answer any questions that you all might have regarding my testimony. So thank you for your attention.
Thank you for being here. Questions, members? I'm sorry. Senator Zephyr.
Yes, ma'am.
Professor Snead, what evidence do you have that an unborn child experiences fetal pain at 20 weeks?
Well, so I'm a legal expert. The question is the interest in fetal pain a legitimate interest, a new interest that would justify a state like Texas to act on behalf of the unborn child? You all will hear from medical experts that will testify to the substantial medical evidence on that particular point. That's not something that I'm an expert in. But I will say one thing, a legal point that is relevant to your question, however, is in 2007, the Supreme Court in Gonzalez versus Carhart said that you all as legislators are permitted, consistent with the Constitution, to evaluate medical evidence, including competing opinions of medical evidence by experts, and to take a position on that particular question. You'll recall in 2007 the case was about partial birth abortion, intact dilation and extraction abortions. There was a disagreement among medical experts about whether there was any circumstance in which that procedure would be medically indicated. And the court, the U.S. government, the federal partial birth abortion ban of 2003, took a position as to who they thought was right on the question of the medical necessity. And then the courts, of course, had an evidentiary hearing on that very question. And what Justice Kennedy said in his opinion in 2007 is that just because there's disagreement on a point about medical evidence doesn't mean that you all can't act in the face of such disagreement if you're convinced that substantial medical evidence supports the view under consideration. So you all should feel free to evaluate the evidence that's presented and make a judgment on your own about which you think is more compelling to support your legislative decisions.
Are you familiar with Senator Hager's Senate Bill 13 from the first special session?
No, ma'am, I'm not.
Focused only on the 20-week unborn child in fetal pain.
Okay, so what you're saying is there was a bill that was separate from the regulatory dimension that you all have been discussing so far.
Senate Bill 13.
Right.
In your opinion, is that bill, or do you have an opinion regarding whether that particular part of Senate Bill 1 is so important that it should be separated into a bill that is not related to these other issues, such as the standards and facilities?
So I would have to read that bill to make a judgment like that. Now, the section that I'm testifying on regards the prohibition on 20 weeks. I only looked at that particular question to determine whether or not that was a sufficiently new, compelling state interest to warrant restrictions on abortion even at 20 weeks before, at least currently under medical technology, before viability of the child is extant. But just to answer your question, though, it seems to me that that it is a very weighty interest that I think the court would treat as a new interest, and if one were to speculate about how different justices would vote, because at the end of the day, what matters most is what Justice Kennedy's view is on this question. Justice Kennedy has signaled an openness to these new interests, and I think there's very strong reason to believe that he would support a bill that was rooted in concerns about unborn children experiencing pain as sufficiently justifiable to warrant this outcome. Now, I understand that the bill has a severability provision, so there's certain aspects of the bill were struck down, other aspects of the bill would survive. But I'm not familiar with the earlier bill. But I do think, just speaking on my own, without taking a position on the regulatory strictures that you all have been discussing, that this is a very significant concern, and I think that you all are more than justified in acting on the interest of a 20-week unborn child.
To clarify then, to underscore your point, you are a professor of law.
That's exactly right.
Your testimony is about the constitutionality of the issues. You're not under any circumstances providing us with medical evidence that an unborn child experiences fetal pain.
That's exactly right. That's exactly right.
Thank you, Madam Chair.
Senator Taylor, you next.
No, thank you, Mr. Chair. Madam Chair, I just want to know how have federal courts handled other states' fetal pain laws?
That's a great question. So the only federal court, the Federal Court of Appeals that has issued an opinion is the U.S. Court of Appeals for the Ninth Circuit, which, of course, as you may know, is headquartered in California, is the most by far overruled court in the country. And what they held in evaluating a law in Arizona that is distinguishable from this law, they found that law to be unconstitutional. But that's we could talk about the differences between this law and that law if you like. And there's also a federal district court, but I should say before the Ninth Circuit took that position, the federal district court in Arizona actually affirmed the Arizona law. He was reversed by the Court of Appeals. And then there's a district court judge in Idaho who I understand also overturned an Idaho law on the grounds that it was sort of unelaborated, but the main grounds was he thought that the law conflicted with the Supreme Court precedent, Planned Parenthood versus Casey, which I think is a misreading of that opinion. I'm happy to elaborate as to why I think that is. I think the strongest reading of those precedents, and in fact, let me go ahead and do that. So the issue is, the question is viability, right? The viability was identified in 1992 in a case called Planned Parenthood versus Casey as an important marker at and after which the state had a very important and pressing interest in acting in the name of the unborn child, also acting in the integrity of the medical, and on behalf of the integrity of the medical profession, and so on. So what the court in Casey did, what the court was trying to do, was to try to actually give states more latitude than Roe v. Wade had given them to restrict abortion. And so they said, instead of Roe's trimester framework, which created a kind of sliding scale of state interest that was weak in the first and second trimesters and then very strong, or in principle very strong in the third trimester, they said, we're going to adopt basically a pre-viability versus post-viability dichotomy. And what they're going, and so at viability or after viability, the state's interest is very strong, and the courts and the states can ban abortion subject to certain narrow exceptions to the life and health of the mother. But even before viability, the court said that the state can act to restrict abortion so long as it doesn't unduly burden a woman's right to abortion. However, it did say, it made a point of saying that the state can enact regulations that can make it more difficult to get an abortion or even more expensive to get an abortion. So if one looks at what the court was trying to do with viability, you actually see why the fetal pain rationale is compelling. What the court has always been trying to do since 1973 is identify lines that it could draw to distinguish state interests that are weighty enough to justify restrictions on abortion. And what this law does, what the fetal pain law does, is actually provide a new line based on the fetal pain rationale that Senator Zaffirini and I have been discussing, that actually is arguably stronger than the viability rationale. Because viability, at the end of the day, doesn't really say much about the sort of moral status of the unborn child. What it is about ultimately sort of respiratory lung development. It doesn't track the usual normative markers that people talk about when they're asking questions about who the unborn child is and what do we owe to her and how does that obligation stand in relation to other goods like women's freedom to make decisions about their medical decision making. So what's interesting here is the court's emphasis on viability actually shores up support for this new rationale, namely the fetal pain rationale that we've been discussing, because it's a line like viability that signals a moment, and this is the court's exact words, where the independent existence of a second life can, in reason and all fairness, be the object of state protection. The notion of a being that can experience pain is a very strong rationale to establish a second person whose interest can properly be taken account by the state. So, this is I think this is how Justice Kennedy, I think, would read Casey, how he would extend it and apply it to this particular instance.
Thank you. Thank you,
Sure.
Okay. Senator West, you're next, but I would ask all members to please keep your questions streamlined out of respect to all the people that are standing out there.
And thank you very much for your testimony here. Right now, then, in the Ninth Circuit and in other circuits too, we have preliminary injunctions against this 20-week ban.
I think there are four. My understanding, you may have more current information than I do. My understanding is that there are injunctions in Arizona and Idaho, Georgia. The Georgia Fulton County Court, based on the Georgia state constitution, enjoined the Georgia fetal pain bill. So I think there are actually 3 jurisdictions in which that's the case. In Arkansas, they enjoined a fetal heartbeat law, which included a part that related to fetal pain, but my understanding is that the fetal pain provision is still in effect in Arkansas. It's only the fetal heartbeat law that's been enjoined.
So this is going back to the Supreme Court bottom line.
For sure. Yeah, absolutely. I would think so. And that's why my testimony focuses on Supreme Court precedent rather than on, for example, Fifth Circuit precedent, which of course governs you all. The Ninth Circuit governs a region of the western part of the country. You all are, as you well know, in the Fifth Circuit. So I think for your purposes, if I were in your seat, what I would most want to think about is how is the Supreme Court likely to deal with this very novel state interest that you're asserting in children who are capable of experiencing pain.
What's the concept of insurmountable obstacle to getting?
If the word was substantial obstacle, the court it's not surprising. Planned Parenthood versus Casey is a pretty confusing opinion. It says pre-viability. There should be no. On the one hand, it says there should be no undue burden on a woman's right to make the ultimate decision to obtain an abortion. An undue burden is defined. It's not really a definition. It's just sort of a synonym as substantial obstacle. Hard to know what that means. But then in the next breath, the court says, but of course, states can take the step of restricting abortion in the name of other goods.
Yeah, hold your point there.
Yes, sir.
In terms of the Supreme Court, have they had an occasion to define what an undue burden is?
No, all we can do is look at what they've affirmed as not an undue burden. In fact, since Casey, there's only one restriction on abortion that has ever been struck down based on the undue burden standard, and that is a spousal notification provision of the Pennsylvania Abortion Control Act. So this is also important, I think, if I were trying to imagine what the court would do. Justice Kennedy, who would be the fifth vote, obviously, in this kind of a case, has never struck down any restriction on abortion that he's ever considered except for spousal notification. So waiting periods, informed consent, a whole array of restrictions, partial birth abortion bans, those have all been affirmed. And the partial birth abortion ban is especially interesting because that applied pre-viability and post-viability. And so Justice Kennedy affirmed that ban on a particular procedure of abortion in 2007. So all we can do is draw inferences about what an undue burden is by virtue of what the court strikes down. And the only thing that they've struck down, 5 justices, of course, being the most important number in this case, is spousal notification provision.
Thank you, Madam Chair.
Senator Rodriguez?
Yes, just one question. I want to follow up, and I know you stated you're not passing judgment on medical evidence. You're not a doctor. You're here as a legal expert.
Right.
But as a legal expert, though, when you make a reference to the requirement that, or the statements that there is substantial evidence to support the fetal pain, have you actually looked at the body of evidence out there to determine whether there's substantial evidence or not as a lawyer? Because normally one would do that.
That's a good question, Senator. Thank you for asking that question. I am, again, not an expert on the medical neurological development of the unborn child from gestation throughout the process until birth. I'm aware that there is a very large body of peer-reviewed evidence that you all would consider, and it's, of course, your responsibility to review that evidence and decide what you think about it and determine you're elected representatives, and it's your job to consider all of that evidence. There will, I imagine, be experts who will testify on these particular questions. There's almost certainly people that disagree with each other about it, as they do on all scientific questions. All I can say in response to your question is, as a lawyer, not a scientific expert, that I am aware that there is a large body of peer-reviewed evidence that points to the neurological development of the unborn child at 20 weeks that convinces experts that they do experience pain. I understand also that there are those who disagree with that proposition. And so, again, all I can do is tell you that you should feel empowered to look at all the evidence and make a judgment about what you find persuasive in this particular area. And the Supreme Court and the Constitution allows you to make that judgment and act accordingly.
Right. And I guess the question here is, you said that you're aware there's a body of evidence out there. The question would be, is it a substantial body of evidence? And one would also want to weigh the reports and the qualifications and the findings of the various reports.
Absolutely.
I think those of us who have looked at this have been pointed to the American Medical Association's journal as the leading evidence
Are you
on
referring to
this
the
issue.
2005 article?
Yes, yes.
That's
And
so, yeah, there's a 2005
and there's
article.
other
Sorry,
follow-up,
please, yeah,
reports.
again, I'm not an expert. My understanding of the 2005 article is, my understanding is a little bit controversial. There was the editor of the Journal of the American Medical Association noted that the author of that article, who was a medical student, not a medical practitioner, who was also affiliated with an abortion practice and I think maybe even the National Abortion Rights Action League, that there were certain kinds of potential conflicts of interest written by that, and that was a literature review. That wasn't actually an experiment or any kind of research that was performed directly, is my recollection. I could be wrong about that, and I think that was 2005. So that being 8 years ago, my understanding is that there's subsequent evidence. And again, I understand recently in the House of Representatives there was a hearing, and Dr. Maureen Condict, who is a neuroscientist from Utah, testified that in her judgment that all the neurological structures, and she was she is a well-regarded expert in this particular area. But again, I don't want to take your job from you. Your job is to look at the evidence, decide what you think is most compelling, and make a decision accordingly. But
Thank you.
Yeah, please. Thank you.
Senator Campbell.
Thank you, Madam Chair. I just would like to say, regarding pain and the scientific evidence that we have for the pain receptors in the body, there is in the literature, Senator, numerous articles, especially in the anesthesia literature, that support what we're saying about the fetal pain. Not just one article that definitely have questions about conflict of interest, but and even in the anesthesia literature, when it talks about some are not making a decision whether pro-life or pro-choice, they're literally just defining the nociceptors, the pain receptors that actually come from the brain. They are developed by 20 weeks, 5 months, and so I guess I would say I've got those articles in my office. I'm happy to share those with you. And I think when people look at the medical specialties that deal with pain, anesthesia tops the list of those specialties that deal with pain. So I do have it. I'm happy to provide that to any of you. Thank you, Madam Chair.
Thank you.